in the judgment of VG versus TM. And this is also an appeal from the regional court under ZAECMHC 39, 30 May 2024. And that is under the pen of Hinana AJ, bundle page 115, summary page 8, for those of you who are following along. The issue in this matter, as we see at least one or two of these judgments every month, forfeiture of patrimonial benefits, Section 9.1 of the Divorce Act, an appeal from the regional court. The parties were married in 1991 in community of property, separated in 2022, and divorced in 2023. There was a forfeiture order granted by the regional court. The appellant challenged the regional magistrate's order and argued that there was no substantial misconduct to justify such forfeiture. Now, as we know, substantial misconduct is one of three factors that may rise to a forfeiture order, the others being the factors or the circumstances which gave rise to the breakdown of the marriage and the duration of the marriage. Those three aspects are looked at cumulatively, and the court must then frame a picture of whether there will be a undue benefit to one of the parties if the forfeiture is not granted. In this instance, the court also looked at contribution of the parties. And folks, this is something which I think is very, very ripe for case law to be made on, because more and more we are seeing the courts look at contribution when contribution is not necessarily a factor that is contained in Section 9.1 under misconduct, circumstances, and duration. And I think incorrectly so, because I think contribution of the parties is patently relevant. So it's going to be interesting to see how this develops in coming months or years. In this instance, the appeal was upheld and forfeiture then failed. There was a division of the joint estate. Now, guys, remember, forfeiture is a heck of a fact-specific issue. It is something that we have to look at in terms of the facts and the merits of each particular matter. Notable quote is paragraph 17. Regional magistrate identified inter alia the fact that the appellant had children out of wedlock and the effect that his actions had on the respondent's health as factors that put a strain on the marriage. Those are factors that led to the breakdown of the marriage, but they do not, according to evidence, constitute sufficient basis to warrant forfeiture of benefits flowing from the marriage regime. It is common cause between the parties that they were planning to build the marital home and they apportioned financial responsibilities in that the appellant bought bricks and the respondent bought iron sheets. Both parties contributed, therefore forfeiture failed. VG versus TM, and that is from the Eastern Cape High Court under appeal under the pen on Hinana AJ.